Trump's legal team reportedly did something so extraordinary that veteran attorneys inside the federal courtroom described it as almost unimaginable. In the middle of active proceedings, while the judge was still speaking, Trump's lead lawyers stood up, gathered their papers, and walked out of the courtroom in full view of the bench. What followed sent immediate shockwaves through the legal community, as the judge issued an arrest warning that observers say could fundamentally alter the trajectory of the case. When attorneys with decades of high-stakes trial experience abandon their client mid-proceeding, legal analysts agree it signals that something has gone catastrophically wrong. According to courtroom transcripts obtained just hours after the incident, tensions had been escalating throughout the morning session as prosecutors introduced evidence the defense repeatedly objected to, calling it fabricated, misleading, and legally inadmissible. But the situation exploded at precisely 11:47 a.m. Moments after Judge Patricia Caldwell issued a ruling that witnesses say sent Trump's legal team into visible panic. Sources inside the courtroom report that lead attorney Robert Sterling's face turned ashen before he abruptly rose and announced the defense could no longer continue under the court's conditions. This was not a routine disagreement or a heated exchange. It was three attorneys simultaneously collecting their materials and heading for the exits while a federal judge was mid-sentence, a move experts are already labeling professional self-destruction. The morning had begun with what appeared to be standard procedural arguments over the admissibility of financial records, but according to sealed filings that were briefly uploaded to Pacer for just 17 minutes before being removed, prosecutors had quietly submitted new evidence less than 48 hours earlier. That material allegedly showed direct communication between Trump and multiple co-defendants during a period the defense had previously described as a complete blackout with no contact of any kind. The documents reportedly included encrypted message logs, wire transfer confirmations totaling $4.7 million, and what one source described as the most damaging paper trail the prosecution has presented so far. When Judge Caldwell ruled at 11:43 a.m. that all 847 pages would be fully admissible, everything unraveled. Court reporter Maria Rodriguez documented every word that followed, and legal analysts say Sterling's statement before walking out left them stunned. According to the transcript, he declared, "Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in what has become a predetermined show trial." His co-counsel, Jennifer Matthews, reportedly followed without comment as the courtroom descended into stunned silence. What began as a seemingly routine legal morning rapidly spiraled into one of the most explosive courtroom moments seen in years, an incident that experts now say may have irreversible consequences not just for the defense, but for the future of the entire case. Sterling reportedly went even further before turning away from the bench, adding, "This is prosecutorial misconduct at its worst, and we refuse to legitimize it with our presence." But what truly set the courtroom buzzing wasn't said aloud. According to three independent sources seated near the defense table, Trump himself allegedly leaned toward his remaining local counsel and whispered a line that instantly began circulating among reporters. "Let them arrest me. It'll guarantee the nomination." The judge's response was immediate, and unlike anything most observers had ever seen. Judge Patricia Caldwell, a Reagan appointee with 31 years on the federal bench and a reputation for restraint and professionalism, abruptly summoned court security. Her exact words, as captured in the transcript, were chillingly direct. "Counselors, if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." She then pivoted toward the prosecution table and delivered a statement that even veteran prosecutors later admitted made them gasp. "I will not tolerate theatrical departures designed to prejudice potential jurors," she said. "This is a court of law, not a reality show." As the courtroom absorbed the shock, Sterling and his team continued moving forward, and that's when events crossed into territory unseen in a federal courthouse in more than 2 decades. Judge Caldwell ordered U.S. Marshals to block every exit. Within seconds, 6 armed marshals positioned themselves at each door as the judge continued. Her voice steady but unmistakably firm. "You will return to counsel table immediately, or I will remand you into custody until you are prepared to fulfill your professional obligations." Spectators later said the silence was so complete you could hear a pin drop. Bloomberg's senior legal correspondent, seated in the gallery, would later tweet that she had never witnessed anything remotely approaching this level of confrontation between a federal judge and defense counsel. The standoff lasted exactly 7 minutes and 23 seconds. During that time, Sterling reportedly stood motionless, his hands visibly shaking as he weighed his options. Trump, meanwhile, remained seated at the defense table with what witnesses described as a faint, knowing smile, appearing almost entertained by the chaos unfolding around him. Court security footage reviewed by pool reporters captured the extraordinary tableau. 3 of the nation's highest-paid defense attorneys frozen in place between armed federal marshals and a judge openly threatening arrest. The footage also revealed another striking detail. At 11:54 a.m., Sterling's phone, resting on the counsel table, lit up with an incoming call from a contact saved simply as Rudy. He never answered, but multiple reporters noted that he glanced down at the screen again and again. And just when it seemed the moment couldn't get any more explosive, everything changed. What came next explains exactly why Trump's legal team appeared so desperate to escape that courtroom. According to sources with direct knowledge of the proceedings, Judge Caldwell revealed that she had received a sealed ex parte submission from the Department of Justice earlier that morning. For those unfamiliar with the term, ex parte means only one side. In this case, the prosecution is permitted to see the material. Such submissions are extraordinarily rare in federal court and are typically reserved for situations involving national security threats, witness intimidation, or imminent danger to a cooperating individual. On the record, Judge Caldwell stated that based on the contents of the submission, she was actively considering enhanced courtroom security and the possible sequestration of the jury. Legal experts immediately understood the implication. The prosecution almost certainly has a cooperating witness whose testimony could be devastating to the defense. Suddenly, the earlier walkout made sense. Within hours, former federal prosecutor Andrew McCarthy told Fox News that when defense attorneys in a case of this magnitude hear the words sealed ex parte submission, they know the walls are closing in. Someone on the inside has flipped, he said, and the government is preparing to drop evidence the defense never anticipated. MSNBC's senior legal analyst added further context, explaining that the walkout wasn't simply about disputed evidence being admitted. It was about buying time to determine which associate, aide, or insider had turned state's evidence. According to the analyst, the panic was entirely rational once you realize the defense team had been operating under the assumption that everyone in Trump's inner circle was holding firm. The timing only made matters worse. This explosive courtroom confrontation unfolded exactly 72 hours before Trump was scheduled to testify in his own defense. Sources close to the legal team report that fierce internal debates had been raging all week over whether he should take the stand. Lead attorney Robert Sterling was reportedly adamant that testifying would be legal suicide, while Trump insisted he needed to tell his side of the story. With the sudden possibility of a cooperating witness ready to testify, that calculus changed instantly, and dramatically. But the shock didn't end there. After the 7-minute standoff finally concluded and Sterling's team returned to counsel table, Judge Caldwell invoked what many legal experts described as a nuclear option. She announced, "Given counsel's attempted abandonment of their client mid-trial, I am considering appointing shadow counsel to ensure the defendant's Sixth Amendment rights are protected." For context, shadow counsel refers to court-appointed backup attorneys who sit at the defense table, prepared to assume representation immediately if the primary legal team attempts to withdraw or is removed. It is the legal equivalent of understudies waiting in the wings, except the stakes involve a defendant's freedom and the integrity of the trial itself. The financial consequences could be just as severe. Sterling's law firm, which according to FEC filings has already billed more than $12 million in legal fees, now faces the possibility of sanctions that legal experts say could climb into 7 figures. What began as a dramatic walkout had now escalated into a full-blown crisis, one with legal, financial, and political ramifications that may extend far beyond the courtroom. But the stakes for Sterling and his team go far beyond embarrassment or courtroom reprimands. Attempting to abandon a client mid-trial can trigger formal disbarment proceedings, a consequence that could permanently end legal careers. Within hours of the incident, the New York State Bar Association released a carefully worded statement confirming it was actively monitoring the situation and reminding attorneys of their non-withdrawable ethical obligation to clients once trial proceedings have begun. 3 prominent legal ethics professors interviewed by the Wall Street Journal were even more blunt, agreeing that Sterling and his colleagues could face career-ending sanctions if disciplinary bodies determine the walkout crossed ethical lines. And this is where the situation becomes deeply alarming, not just for the defense team but for the justice system itself. This incident is no longer about a single defendant or a single courtroom. If lawyers are permitted to abandon trials whenever rulings don't go their way, the entire judicial framework collapses. Judge Caldwell appeared acutely aware of that danger when she warned from the bench, "The court will not permit counsel to manipulate proceedings through calculated disruptions." Such tactics, if successful, would encourage every losing party to manufacture a mistrial through counsel withdrawal. Her concern is shared by legal scholars nationwide. Once that precedent is set, any defendant facing conviction could simply instruct their attorneys to storm out, claim bias, and demand a reset. Meanwhile, the political fallout was immediate and explosive. Within minutes of the news breaking, Trump posted on Truth Social, "My lawyers are fighters who won't stand for this rigged trial. Judge threatening arrest. Election interference." The post reportedly surpassed 2.3 million views in its first hour alone. Republican lawmakers moved quickly to amplify the narrative, with Senator Tom Cotton tweeting, "When judges threaten to arrest attorneys for defending their clients, we've entered banana republic territory." Democrats responded just as forcefully, with Senator Elizabeth Warren firing back, "No one is above the law, including lawyers who attempt to sabotage judicial proceedings." But what happened next revealed just how calculated this entire confrontation may have been. Court filings show that within 30 minutes of returning to their seats, Sterling's team submitted an emergency motion for mistrial, citing judicial bias and prosecutorial misconduct. They also filed a motion to recuse Judge Caldwell, arguing that her threat of arrest demonstrated personal animus toward the defense. And here's the strategic brilliance. By engineering this public confrontation, the defense has now created multiple appeal pathways regardless of how the trial ultimately ends. Legal analysts across the spectrum agree this was not just a reaction to unfavorable rulings, but a performance staged for an audience far beyond that courtroom. The prosecution responded with equal force. Lead prosecutor Michael Harrison, known for securing convictions against 3 Fortune 500 CEOs, immediately filed a motion for sanctions against the defense. Submitted at 2:47 p.m. The motion seeks substantial financial penalties against Sterling and his colleagues, setting the stage for what may become yet another high-stakes battle layered onto an already unprecedented case. The prosecution's response raised the stakes even higher. Lead prosecutor Michael Harrison asked the court to impose daily sanctions of $50,000 per attorney, to continue accruing until the defense could demonstrate proper courtroom decorum and respect for judicial authority. Harrison went further, leveling a stunning accusation that the walkout was not spontaneous at all, but pre-planned and deliberately coordinated with sympathetic media outlets to manufacture a narrative of persecution. According to the motion, Fox News camera crews were already positioned outside the courthouse 45 minutes before the walkout occurred, and several conservative commentators had begun tweeting about judicial tyranny before any public report of the incident had emerged. Prosecutors argue that timing alone strongly suggests orchestration rather than coincidence. And timing in this case is everything. Remember the sealed ex parte submission Judge Caldwell referenced earlier. Sources within the Department of Justice now suggest it pertains to testimony scheduled for next Tuesday from an individual identified only as witness 14 in court filings. This witness allegedly has direct knowledge of financial transactions that sit at the very center of the government's case, and has reportedly been in protective custody since October. The defense team's dramatic walkout occurred just 96 hours before that testimony is set to begin. Legal analysts across the spectrum say the implication is impossible to ignore. Even more revealing is what happened out of public view during the lunch recess. According to 2 sources with first-hand knowledge, Judge Caldwell convened an emergency closed-door meeting in her chambers with both legal teams present. There, she reportedly issued Sterling and his colleagues a blunt ultimatum. Conduct yourselves as officers of this court, or prepare to find yourselves as defendants in your own criminal proceedings. She also disclosed that the U.S. Attorney's Office for the Southern District of New York had already drafted contempt charges and could file them within minutes if necessary. Sterling, normally known for his aggressive and confrontational courtroom style, reportedly sat in stunned silence. The afternoon session that followed was no less tense. Trump's attorneys resumed cross-examination of a financial forensics expert, but observers noted their focus appeared fractured. Body language specialists reviewing the footage later pointed out that Sterling repeatedly checked his phone beneath the table. Jennifer Matthews was seen taking anxiety medication, and third chair counsel David Park avoided eye contact with the judge entirely. Trump, by contrast, appeared energized by the chaos of the morning, frequently passing handwritten notes to counsel and occasionally smirking as prosecutors made key points. And finally, there's the precedent, because this has almost never happened. Only 3 times in modern American legal history have defense attorneys attempted to abandon their clients mid-trial in federal court. In 1978, mob lawyer Frank Ragano tried to walk out during the Santo Trafficante trial and was immediately threatened with disbarment. In 1992, during the BCCI banking scandal, 2 defense attorneys attempted to withdraw and were forced to continue under threat of contempt. And in 2009, Bernard Madoff's original legal team attempted to quit 2 days into testimony but was compelled to remain by court order. In every instance, the judiciary made one principle unmistakably clear: once a federal trial begins, walking away is not an option. Here is a full, polished, high-impact rewrite of that section, maintaining the tone, detail, and escalation while tightening clarity and narrative authority. In all 3 historical cases, the outcome was the same. The defendants were ultimately convicted, and the attorneys involved faced severe professional consequences that permanently altered their careers. That reality raises a question worth confronting. What exactly should Trump's lawyers have done instead? They were clearly trapped between impossible choices. On one side stood a client who, according to multiple sources, has grown increasingly difficult to manage and has pushed for strategies his own attorneys privately view as legally catastrophic. On the other stood their professional and ethical obligations. Obligations that, if violated, could cost them their licenses to practice law. $12 million in legal fees may be substantial, but it becomes meaningless if you can no longer practice law at all. What makes this moment even more fascinating is how the jury appears to be processing the fallout. While jurors were not present during the walkout itself, observers say the tension that followed was unmistakable. Juror number 7, a retired Brooklyn schoolteacher, was seen repeatedly shaking her head during defense arguments that afternoon. Juror number 3, a small business owner, appeared to take extensive notes every time Judge Caldwell addressed the defense team directly. Jury consultant Dr. Patricia Williams explained to CNN that this kind of courtroom conflict often backfires. When jurors witness open hostility between a judge and defense counsel, she said, they frequently interpret it as consciousness of guilt. Why else would lawyers risk their careers unless they believed their client was in serious trouble? Security concerns only deepened that impression. Following the morning's confrontation, the U.S. Marshals Service elevated courthouse security to its highest level. Additional metal detectors were installed, enhanced screening was imposed on all entrants, and NYPD units were repositioned around the courthouse perimeter. The FBI's New York field office reportedly placed agents on standby. This is not standard procedure for a white-collar federal trial. It signals that authorities are genuinely concerned about disruptions, or worse, as the case approaches a critical phase. And there is one detail that has received surprisingly little public attention. During the afternoon session, a note was discreetly passed to Judge Caldwell, prompting her to immediately call a sidebar. According to sources familiar with the exchange, the note came from court security and warned that several individuals with known ties to far-right militia groups had been observed near the courthouse. While there was no indication of a specific threat, their presence injected yet another layer of volatility into an already combustible environment. The judge reportedly warned both legal teams that any attempt to incite public disorder, directly or indirectly, would be met with the full force of federal law enforcement. But beyond the immediate spectacle, this episode exposes something far more troubling. It highlights how defendants with immense resources and political influence can attempt to transform criminal trials into ideological theater, eroding public trust in the justice system itself. As Professor Jonathan Turr, if tactics like this are allowed to succeed, the implications are profound. Every high-profile defendant facing serious legal jeopardy will attempt similar disruptions, turning courtrooms into political stages and eroding judicial authority itself. And just when it seemed the situation couldn't escalate further, new revelations emerged that stunned even seasoned legal observers. Late Friday evening, just as financial markets closed, Bloomberg reported that Sterling's law firm had entered emergency talks with its malpractice insurance carrier. According to sources familiar with those discussions, the insurer is deeply concerned about potential liability if the attempted walkout contributes to a mistrial or forms the basis of a successful appeal. Industry insiders say the firm's coverage could be at risk entirely, potentially exposing senior partners to personal financial liability for damages. That concern may explain why multiple senior partners were reportedly seen arriving at the firm's Manhattan offices shortly after 10 p.m. Friday night for what was described as an urgent crisis management meeting. The fallout wasn't confined to the United States. International legal observers reacted with disbelief. The United Kingdom's former Director of Public Prosecutions remarked that in any common law jurisdiction, such conduct would likely result in immediate custody. French newspaper Le Monde ran a headline translating to "American Justice in Chaos as Trump Lawyers Defy Judge," while even Russian state media seized on the incident as purported evidence of institutional decay in the U.S. legal system. Meanwhile, troubling new details continued to surface about what actually triggered the walkout. A paralegal associated with the defense team, speaking on condition of anonymity, claimed that Sterling received a text message at 11:42 a.m. just 5 minutes before the walkout, that read simply, "Abort mission." According to the source, the message came from a senior Republican strategist who had been advising the team on public relations strategy. If accurate, it strongly suggests the dramatic confrontation was orchestrated for political optics rather than legal necessity. Judge Caldwell appears to have reached a similar conclusion. In a rare move, she issued a written order late Friday evening that included a striking passage. The court has reason to believe that certain theatrical elements of today's proceedings were coordinated with outside parties for purposes unrelated to the fair administration of justice. Any future attempts to transform these proceedings into political performance art will be met with a full range of sanctions available to this court, including but not limited to contempt charges, financial penalties, and referral to appropriate bar authorities. Even some of Trump's most loyal defenders in the legal community are now struggling to justify the episode. Alan Dershowitz, who has frequently defended Trump's legal positions, admitted on Newsmax, "Walking out on a federal judge is simply indefensible. There are proper channels for addressing grievances, and abandoning your client mid-trial crosses a line." Mid-trial, however, is not one of those proper channels, and when even Alan Dershowitz won't defend your conduct, it's a clear sign a serious line has been crossed. The fallout is no longer confined to the courtroom. Financial markets are now paying close attention. Legal risk analysis firms that advise institutional investors issued emergency briefings warning that a mistrial could prolong proceedings by 6 to 12 months, potentially disrupting Trump's business operations and compressing or reshaping his political timeline. One hedge fund manager, speaking off the record, said his firm had already begun adjusting positions based on the growing likelihood of extended legal instability. When lawyers literally try to flee a courtroom, he noted, it usually means they know something the market doesn't. And here's what almost no one else is reporting. According to sources inside Trump's inner circle, serious discussions are now underway about replacing the entire legal team. The names being floated include some of the most controversial defense attorneys in the country, lawyers known for representing war crimes defendants and terrorism suspects. The thinking, according to one source, is blunt. If we're going down swinging. That possibility places Judge Caldwell in an almost impossible position. Allowing Sterling's team to withdraw at this stage could delay the trial for months while new counsel gets up to speed. Forcing them to continue, however, risks creating substantial appellate claims of ineffective assistance of counsel. It's a legal catch-22, and several former federal clerks say it appears to have been engineered deliberately. One former Supreme Court clerk described the maneuver as brilliantly cynical, adding, "They've created a scenario where the judge has no good options." The prosecution, meanwhile, is not standing still. Sources indicate they are weighing an aggressive countermeasure of their own, asking the court to revoke Trump's bail based on the defense team's conduct. The argument would be that a defendant whose legal team attempts to destabilize proceedings presents a heightened flight risk and a threat to the orderly administration of justice. It's an extreme move and would almost certainly fail, but even filing such a motion would dominate headlines and shape public perception. And public opinion is already shifting. A flash Reuters, Ipsos poll conducted Friday evening found that 67% of Americans disapproved of the lawyer's walkout attempt, including 48% of Republicans. More strikingly, 72% agreed with the statement that no one is above the law, including former presidents. Those numbers suggest the defense's theatrical tactics may be backfiring badly in the court of public opinion, even if they succeed in laying groundwork for appeal in an actual courtroom. Finally, there's the looming whistleblower question. That sealed ex parte submission remains the elephant in the room, and legal experts are increasingly focused on one mystery. Who exactly is Witness 14, and how much damage are they about to do? The smartest money now believes Witness 14 is someone from Trump's inner financial circle, possibly a former CFO, controller, or senior finance executive with direct access to the transactions at the heart of the government's case. The fact that this individual has reportedly been in protective custody since October is especially telling. That level of protection is rarely granted unless prosecutors believe a witness faces credible threats, a circumstance usually associated with organized crime, national security matters, or both. If this witness delivers the testimony prosecutors are signaling, it could effectively end the defense's case before it truly begins. And the broader context makes this even more consequential. The timing of this trial was always politically sensitive, but the walkout attempt has supercharged the stakes. With just 11 months until the 2024 election, every additional day in court is a day Trump cannot fully devote to campaigning. Some political analysts now believe the walkout was a calculated attempt to force a mistrial, potentially delaying any retrial until after the election. It's a high-risk, high-reward strategy that treats the courtroom not as a forum for justice, but as another political battlefield. Judge Caldwell appears determined not to let that happen. Sources familiar with her thinking say she is prepared to hold court 6 days a week if necessary to keep the case moving. She is also reportedly weighing restrictions on media access if she concludes that coverage is encouraging theatrical behavior, an extraordinary step that would almost certainly invite First Amendment challenges, but one that underscores how seriously she views the threat to judicial integrity. Strip away the spectacle and the conclusion is stark. What unfolded wasn't merely aggressive lawyering. It was an attempt to convert American courtrooms into political theater. When attorneys feel empowered to walk out on federal judges, when defendants treat trials as campaign opportunities, and when justice begins to resemble reality television, a dangerous line has been crossed. The next few days will be decisive. On Monday morning, Judge Caldwell is expected to rule on the defense's motions for mistrial and recusal and decide whether Witness 14's testimony will proceed as scheduled. She has already made clear that any further disruptions will result in immediate arrests. U.S. Marshals have reportedly been briefed on arrest procedures for attorneys, something that has not been necessary in a federal courthouse in living memory. Even political support is beginning to fracture. Senator Mitt Romney released a statement emphasizing that respect for the judicial system is foundational to democracy, and that attempting to flee a federal courtroom crosses every conceivable line. More telling still, Senator Josh Hawley, typically a staunch Trump defender, acknowledged that attorneys must follow proper legal procedures when asked about the incident. And when even reliable allies begin to hedge, it's a sign the strategy has gone too far. What makes this moment truly troubling isn't just the legal brinkmanship or the political theater. It's the damage being done to public faith in the justice system itself. Every American is entitled to their day in court, represented by competent counsel operating within well-established rules. When those rules begin to fray, when attorneys attempt to flee rather than confront adverse rulings, it sends a dangerous message that justice can be bent, stalled, or derailed by those with enough money, influence, and audacity. That isn't justice. It's chaos masquerading as strategy. I've covered legal proceedings for more than a decade, And I've never witnessed anything remotely like this. Yes, lawyers argue aggressively. Yes, judges occasionally lose patience. But attorneys attempting to physically leave the courtroom while a federal judge is speaking, only to be stopped by U.S. Marshals under threat of arrest, pushes this into unprecedented territory. This isn't just a dramatic episode. It's a stress test for the very foundations of our legal system. And the implications stretch far beyond this one trial or this one defendant. If Trump's legal team succeeds in turning criminal proceedings into political spectacle, every future defendant with sufficient resources will be tempted to follow the same playbook. Imagine a system where wealthy defendants simply instruct their lawyers to walk out whenever rulings don't go their way, where trials become viral content instead of serious searches for truth, and where judges are forced to threaten arrest just to maintain basic order. That's not a functioning justice system. It's anarchy dressed up in legal briefs. As we head into what promises to be a pivotal week, one principle matters above all else. The rule of law only works when everyone, defendants, prosecutors, judges, and yes, attorneys, plays by the same rules. The moment one side decides those rules no longer apply, when they literally attempt to walk away from the process itself, we all lose. The questions now are stark and unavoidable. Can Judge Caldwell restore order without triggering further chaos? Will Trump's legal team escalate their disruptive tactics or retreat? And most importantly, can the American justice system withstand this unprecedented challenge to its authority and legitimacy? Stay tuned, because this story is far from finished. When Witness 14 takes the stand, when Judge Caldwell rules on the mistrial and recusal motions, when we finally learn who sent that abort mission text, the consequences will be immediate and profound. This is no longer just about one courtroom or one political figure. It's about whether America still believes that no one, no matter how wealthy, powerful, or politically connected, is above the law. The answer to that question may shape this country for generations to come.